Ms. Garrett?
Good morning, Your Honors. My name is Attorney Melissa Garand from Kaufman and Frederick, and I represent the appellant Joseph Cahill. The Court of Appeals made the correct decision in this case. This is not a situation, as the Commonwealth suggests, where the Court of Appeals undermined the legislature. The facts in this case just did not meet the elements of the statute. The conduct of the defendants that is at issue in this case, as identified by the Commonwealth, is the incident where Cahill came up from behind Robinson, grabbed her from behind, arms around her shoulders. The evidence at trial and the findings of the Court of Appeals were that he grabbed her by the shoulders, not around the neck.
Are you taking the position that grabbing someone around the shoulders in and of itself could not be offensive?
Yes, I am, Your Honor.
But that grabbing someone around the neck could be offensive?
No, my position, I'm not conceding that even if he grabbed her around the neck, that would have met the offensive portion of the statute. I just want to clarify what the facts are for the record, what the findings were, the testimony at trial.
Don't we have to look at this in the whole context of everything he was doing? Wasn't he ogling her and a few other things besides this?
Yes, but if you look at everything that he was doing, it would really go to what her state of mind was. He did nothing in a violent manner.
Well, while he was touching her wherever it was, the shoulders or the neck, wasn't he also saying, "I love you"?
Yes, he did, and that goes to my argument that that's why that this did not meet the threatening aspect of the statute.
Well, it doesn't have to be threatening, does it? It simply has to be physically offensive.
Well, there's two portions. It could, yes, it could have been physically offensive. He didn't meet the threatening part of the statute, and he also didn't.
But it doesn't have to be threatening. It only needs to be physically offensive.
Right, for no legitimate purpose.
Yeah.
And in this case, my argument is that it wasn't physically offensive because if you look at the way that this statute has been interpreted by the courts in the past, there's been an element of violence here. There was absolutely no element of violence in the situation.
You mean he has to draw blood?
No, absolutely not. If you look at how the Court of Appeals in Commonwealth versus Lepore interpreted physically offensive conduct for no legitimate purpose, there was an element there of a man standing in an alley outside the bedroom window of two women, and the Court of Appeals found in that situation that that was physically offensive because he violated their personal space. He was outside of their bedroom windows.
In this case, the defendant had his hands on this person while she's trying to deal with the public in a supermarket at the cash register.
That's correct. He came up from behind her and he touched her shoulders.
He put his arms around her.
He grabbed her by the shoulders. That's correct. And the Court of Appeals found that there are other statutes that better govern this type
there
of
are often lots of, you know, the Commonwealth, the executive branch can sometimes choose to indict, you know, under Statute A or Statute B, chooses Statute B, but you can't say, if I were the prosecutor, I think it would have been better to do it under the other one, unless you can show what was wrong about doing it under this one.
However, you need to look at there were 3 charges brought against this man. He was found not guilty at trial of an assault and battery.
Well, that's because they didn't find an assault and battery.
Correct. And he was also, there was a required finding of not guilty as to criminal harassment.
Did the judge explain, because this was a jury-waived trial, did he explain how he could find not guilty on assault and battery and yet guilty of annoying and accosting based on, in essence, a physical assault?
Not to my knowledge, Your Honor.
I mean, I don't see how this, I mean, it strikes me that so long as there is criminal intent, this is an assault and battery. I mean, as long as there's an intent to touch,
right,
and an unconsented to touching.
Exactly.
It's an assault and battery.
Right.
I don't understand what the judge was doing here.
I don't understand that either. And I think, again, when you go to the statute, this court has repeatedly held that this is an archaic statute in need of revision. And I think that...
and when we say that and the legislature doesn't act, sometimes it means that the legislature is satisfied that it wants that statute on the books, and sometimes it means that for whatever reason, it hasn't come up in the appropriate, but the statute is on the books.
The statute is on the books, but I think you have to look at how it has been interpreted by this court and the Court of Appeals in the past, and you have to look at the type of behavior that this court has looked at. In Commonwealth versus Peace Chow, this court found that the defendant's behavior in that case was not physically offensive. He had distributed a very, very offensive flyer about the victim and hung it up in the school. This court found that that behavior wasn't physically offensive.
Well, it doesn't have to be physically offensive. In that case, it was threatening speech, wasn't it?
Right.
So in this case, we're talking about physically offensive conduct.
Right. Well, I'm just saying the Court of Appeals found that the defendant's behavior in this case was not threatening because there were no threats. There was no explicit threat.
But
She was never in fear.
I have to look at the statute. The statute has ands and ors, okay? So it has to be offensive and disorderly.
Correct.
It can be an act or language.
Correct.
So there doesn't even have to be
A physical touch.
a physical touching.
That's correct.
And then you accost or annoy. At very least, this was annoyance. It was offensive. And it was taking place, this was not taking place, for example, in somebody's living room. This was taking place, as I understand it, there's a line of people at the checkout counter. He's coming up behind her. He's putting his arms around her. He is engaged in entirely offensive and inappropriate conduct. And, looking at the statute, I don't see where the elements haven't been met here. Now, it may be that the Commonwealth has not previously chosen to indict under the statute, but there may be all kinds of reasons for that include the fact that women weren't working in supermarkets, that the Commonwealth didn't take very seriously accosting of women, and it now does. So to say, in the past the cases are different frankly isn't helpful to me.
Well, I'm saying that the way that the statute has been interpreted in the past has been interpreted as a more violent. There's been a more violent tone to the cases that have interpreted the statute.
You do have to look at it in that way because, in theory, a defendant is supposed to kind of figure out what he can and can't do based on how the statute's been construed in the past. Correct?
Correct. And in the past, the statute has not governed inappropriate touching. There are other statutes that have dealt with that in behavior in the workplace. And now what you're doing is you're looking at inappropriate touching and you're bringing it under the umbrella of the statute.
So what we would have to do is redefine this for the future, and to use a bad term, give your guy a pass on this. Correct?
Well,
because the case law didn't support this conviction for this kind of conduct.
That's correct, Your Honor.
Well, let me take a look at the case in which the appeals court relied, right? The Chu case.
Yes.
Because there are lots of ors. Disorderly acts or language. The appeals court said, look, this is offensive. So, and
yes,
there's no
that's
question
correct.
that this was offensive.
That's correct. They found it wasn't threatening or physically offensive.
Those involve fighting. Well, maybe, maybe not. Or threatening. Violent or tumultuous behavior, or that creates a physically offensive condition.
For no legitimate purpose. Correct.
You're not suggesting this was a legitimate purpose?
No.
Okay, so we're down to physically offensive condition. I think as I read those, it's a physically offensive condition. And oh, by the way, it's not one of those cases where this is conduct that nobody could reasonably believe was criminal because, as Justice Cordy suggested, the chances are it was assault and battery. Mm-hmm. So it's not as if this defendant is not on notice that if he engaged in this kind of conduct, it could be construed as criminal conduct.
Well, again, what I'm maintaining is the cases that have interpreted physically offensive conduct, previously have been cases where there's been a more violent undertone. And I know you're very familiar with Chapter 151B, and I think that you've seen in some of those cases very egregious and outlandish behavior that has not been criminally prosecuted. So you have an individual here.
Well, I don't know if they have been criminally prosecuted because 151B is civil, so I just don't know if it's being criminally prosecuted.
Another aspect of this that you need to consider, though, is whether this individual was a reasonable person. And I would maintain under the statute in this court in Commonwealth versus Peace Chow applied the reasonable person standard in making a determination that the victim had a legitimate fear about being threatened. I would maintain in this case that Robinson was not a reasonable person. Her perception of his behavior was far different than the two other women who she said were also harassed by Cahill. You had two other women who testified at trial who said that he was a friendly man. He may have called them sweetheart if he touched their back, even if they were uncomfortable, they recognized that he was doing it in a friendly manner. Here you have this woman who said that she was accosted. She testified that she was very sensitive to harassment. She had previously settled a harassment suit against her landlord, and I would maintain that she had a heightened sensitivity to this and that under the statute that she was not a reasonable person applying that standard.
So I take it your view is that if you didn't have this particular person who was trying to deal with customers at the cash register at the supermarket, that somebody else in this position, it would not constitute physically offensive conduct, notwithstanding the fact that the other customers are there waiting to be attended to.
I'm maintaining that if this had happened to another individual, it wouldn't have been, they wouldn't have characterized it as accosted behavior. This woman did not report it to her employer for 2 days, did not even go and speak to the police for 6 weeks. She never testified that she was in any way in fear or that she felt threatened. At most, she stated that she felt panicky and that his behavior ultimately annoyed her. She further testified that she wasn't even going to report the behavior, but he did something that he banged on her conveyor belt a couple of days later when speaking to a customer, and at that time she decided that she wanted to report it.
Ms. Garand, let me ask you this. Have you taken a look at the Model Penal Code or the commentary in connection with it? I notice it's not cited in your brief. Is there anything there that might elucidate this?
Could you repeat that, please?
Yes. I said, have you taken a look at the Model Penal Code or the commentary?
I've looked at the Model Penal Code as it's defined in certain cases. And
is there anything in the code itself, because apparently in Chu we pointed to the Model Penal Code and the commentary, is there anything that would throw any light on the interpretation that we should give this here?
There was one thing I noted yesterday. Well, in the Model Penal Code, one of the things that the Court of Appeals found in Commonwealth versus Zattel is that, well, this is for no legitimate purpose. It's conduct that has to further some legitimate desire or objective of the actor. But I think that as to being physically offensive, the Model Penal Code has looked at it more as conduct that has had a more of a public framework and not a private framework, or as in this case. The Court of Appeals looked at two aspects.
Are you saying this has a private framework in this case?
Well, the Court of Appeals looked at it as, in Commonwealth versus Lepore, they recognized that there are two aspects of disorderly, and this court did in Commonwealth versus Peace Chow. There's a public aspect or a private aspect. In Peace Chow, the Court of...
You agree that this was done in public?
Yes, it was. Yes, it was.
Okay.
But I wanted to note that the Court of Appeals, in looking at it, recognized that it wasn't an extreme invasion of privacy, but also found that it also did not believe that it went to the public aspect of disorderly either. In conclusion, I just want to state that the Court of Appeals found that the statute as applied to Cahill was overreaching, and that I respectfully request that this court not extend the statute to situations like Cahill's.
Thank you, Ms. Gouland. Ms. Pappas?
May it please the Court, Marion Pappas, Assistant District Attorney for Middlesex, with Assistant District Attorney Ms. Loretta Rios. The trial judge properly denied the defendant's motion for a required finding of not guilty on the charge of accosting or annoying a person of the opposite sex. The defendant's conduct at issue in this case happened on or about April 10, 2003, when the defendant came up from the victim when she was working at a register, came from behind her, grabbed her tightly around the neck with his arms wrapped around her shoulders, and held on to her for 10 or 15
Can we just clarify the business about where he grabbed her? Was it the neck or the shoulders? And where in the record will we find the reference?
Well, I believe it's on page 16 of the transcript. On direct examination, the victim testified, I believe her words were that he grabbed me tightly around the neck with his arms wrapped around my shoulders. A couple pages later, on direct, the prosecutor wanted to, repeat, clarify. He said, he grabbed you around the neck, and she said, around the shoulders. She said, well, it's more around my shoulders. She never said it wasn't around her neck. Furthermore, because the defendant came up from behind the victim, already just placing his arms around her shoulders, he's already around her neck. Her neck's in the middle, between her shoulders. So,
does it make a difference?
No, it doesn't.
Does it make a difference?
Your Honor, it does not make a difference.
Well, it might make this kind of difference, that I think that somebody putting their hands around your neck is an infinitely more threatening gesture than somebody putting their arms around you.
Well,
I'm not suggesting that putting your arms around your shoulders doesn't satisfy it, but certainly if there's evidence to support that he put his hands up towards her neck, that's an extremely threatening.
Surely, if we're talking, it could be threatening, and also certainly more physically, creating a physically offensive condition would certainly be clearer if the person put his arms around her neck from behind, as opposed to maybe around her middle or around her shoulders.
I see the action more as coming up from behind the victim, placing his arms wrapped around her shoulders. She did testify, I believe, on cross-examination. Defense counsel asked, well, was this a bear hug? She said, absolutely not. This
Well,
was
even if
not
it were a bear hug, if this were a public display of unwanted affection, in a while she was trying to do her job, is that physically offensive?
Well,
or isn't that physically offensive?
Well, the Commonwealth believes that this created a physically offensive condition with no legitimate purpose because it was sexually charged, physically offensive conduct.
No, he was also saying, I love you too.
It was saying, I love you, yes, that is correct.
But is it not clear that the record that she had previously told him that she had no interest in pursuing that particular avenue?
Well, previous to this event, between February 1st and April 10th of 2003, the defendant asked her out 20 or more times to go to the Mohegan Sun Casino or to go to dinner, and she said no each time. Furthermore, the defendant was staring at her from the overhang at the Stop and Shop, the second level, sort of a balcony around where the cashiers were working. He was staring at her. He rubbed her back. He grazed the side of her body. And those acts simply increased her level of threat. So by the time that this incident occurred on April 10th, she had already developed a fear of the defendant. It did not reach the accosting and annoying level until he came up from behind and grabbed her.
Does it have to be threatening?
It has to be either physically offensive, created a physically offensive condition, or threatening.
So it doesn't have to be threatening?
It doesn't have to be, but the Commonwealth believes that it was actually both. You could actually find that it was both physically offensive, it created a physically offensive condition with no legitimate purpose, and it was threatening. This court...
And the threat doesn't have to be explicit. It could be implicit.
No, it can be. It can be an implicit threat, and that was in the case of Lepore, where the defendant was standing outside the victim's window approaching it in an aggressive manner, and that was found to be both physically offensive and threatening as well.
Ms. Pappas, let me ask you this. You know, one is looking at the elements and what we said in Chu and sort of passing through that, but it seems that underlying the appeals court's decision is its view that there are other statutes that cover this conduct, and it refers in particular to the civil remedy for sexual harassment, which I think is irrelevant because that's not the Commonwealth bringing that claim. But then it talks about stalking and harassment, and I'm not asking you to, you know, take a position, but is there something that stood in the way of the Commonwealth, and I mean in terms of the evidence that the Commonwealth had at the time, that would suggest that it could not, that whatever happened here would not satisfy the elements of the stalking and harassing statute as we have interpreted it?
As the court has interpreted, Your Honor, it is 3 or more acts that constitute a pattern or series of harassment. Now, this was part of the motion for a required finding, and the judge allowed it. The judge did not, Justice Greco did not specifically say why he allowed it. However, prior to his allowance, he stated that to the prosecutor, doesn't this require 3 or more acts of harassment? And then furthermore, he stated, and I believe it's on page 17 of my brief, that he was against construing the criminal harassment statute loosely. It is 3 or more acts.
So stated differently, if you look at what the trial judge was doing,
Yes.
the Commonwealth is saying, we believe this conduct is criminal. It could be assault and battery, but the trial judge has said it isn't. It could be stalking and harassment, but the trial judge has said it isn't. And so we've got a third statute. In other words, they're not completely overlapping. Am I correct?
They're not, but we do believe in this particular case that this was not criminal harassment simply because...
No, I understand that.
Sorry.
But so for the appeals court then to say,
Yes.
well, you could have done it on these other bases, the Commonwealth is left with a position saying, no, I couldn't because I tried to do it on the other bases. And the trial judge said, in other words, it's not very... It's not as if this is one of those cases where the Commonwealth chose this statute but didn't choose another one that an appellate court thinks might be more... It in fact chose both statutes, correct?
It charged on assault and battery,
And
criminal harassment,
on
costing or annoying.
harassment, criminal harassment.
Yes, and criminal harassment and costing or annoying. All I can really say is that this met statute's requirements. It was certainly accosting or annoying a person of the opposite sex. Surely the victim could have gone forward with a civil harassment claim. However, the Commonwealth has...
Can I ask you,
Sorry.
excuse me, can I ask you just one other question? This starts off, the section, 272.53, deals with common night walkers, common street walkers, male and female, common railers and brawlers, persons who, I mean, to what extent do we say, look, what the Commonwealth was really dealing with here was, you know, people who were out to obtain sexual favors.
Sorry, can you repeat?
Yes, I mean, it starts off night walkers, common street walkers, male and female, common railers and brawlers. I don't know what a common railer and brawler is in this day and age, but I mean, at very least, the legislature was focused on people harassing other people for sexual favor. I mean, we now call it sexual harassment, but this is an old statute and saying if you want sex, you're not allowed to go up and make people's lives a misery in order to get sex from them.
But I do know that in terms of the legislative intent behind this particular provision of the statute, this court found in Peace Chow that the legislative intent behind the accosting or annoying provision was to prohibit conduct that has more of a personal or private impact. furthermore, it stated that the prefatory, this court stated that the prefatory language in the disorderly conduct definition in the Model Penal Code, which I believe is something to the extent of with the purpose to cause public inconvenience, does not square well with the accosting or annoying provision. And so in this particular case, we have, breaking it down for disorderly conduct, we have physically offensive condition with no legitimate purpose or threatening. And in Peace Chow, placing the flyers around the school was found to be threatening. There was no physical element to that, so the court did not find a physically offensive condition. And the court, in finding that it was threatening, looked to the fact that prior to placing the flyers around the school, that the defendant had actually threatened to hit her once before, and after he had broken up, they had broken up, I believe she had broken up with the defendant, he left a very disturbing phone call, I believe. He got very upset, angry on the phone.
So what do we look at in this case to find threatening?
To find threatening in this case, we look at the fact that this was an act coupled with an aggressive move towards the victim. And we also look at the fact that prior to this isolated event, there were a series of other acts, maybe not criminal, but they placed the victim in fear. Before this event occurred, she testified that she was afraid for her safety outside of the workplace, that she was not afraid for her safety inside of Stop and Shop, but outside of Stop and Shop, she was afraid for her safety based on the defendant's conduct. So by the time that we get to the incident on April 10th, she had developed a fear of the defendant, and the fear reached the threatening level when he grabbed her.
What was the panicky level, she said?
She said that she was scared. She said that she was scared and panicky.
What was the date of this indictment?
The date of the indictment.
I thought it was a complaint.
I'm sorry. This was a charge.
When was the conduct?
The conduct occurred on April 10th, 2003, and the jury waive trial was December 12th, 2003.
So put it this way: if you're a prosecutor and you look at Commonwealth against Chu, and you see plenty of language in Commonwealth against Chu about sexually explicit language when directed at particular individuals in settings in which communications are inappropriate and likely to cause severe distress, may be inherently threatening. I mean, it's not as if the statute just came out of the blue, directed to this case, correct?
Yes, and you really have to look at all the case law together, going back from the case 1940 case of Lombard, which stated that you need to have both offensive and disorderly. You need to prove both offensive and disorderly throughout the history of these cases. And reading Peace Chow, reading Lepore, the Defendants Act certainly met the requirements.
In Peace Chow, that was a free speech case, wasn't it?
No.
That was the defense.
No, Peace Chow.
That was the defense in the case, and there were no acts, other than maybe posting, and it was a case of whether or not there were threats. Isn't your case here a lot simpler than that? Isn't it just physically offensive conduct?
We believe it's both. Sorry.
But isn't the more direct, easier approach in this case one of physically offensive conduct?
It certainly is physically offensive conduct.
Isn't that the easier avenue to pursue to get a conviction in this case, from the prosecutor's point of view?
Well, we believe that it is both because it's really two.
That's not what I'm asking.
Okay.
Isn't it a more direct route, given the facts of this case? Isn't it more? Don't the facts of this case lend themselves more to the theory of that the conduct is physically offensive?
Perhaps so.
I'm just curious, if hypothetically, all the same facts except once the defendant put his arms around the person, he, instead of saying, "I love you," said, "I'm going to kill you," we wouldn't have any debate about it being threatened, would we?
No, that would be more like the case of Shawley. We'd find disorderly conduct right away.
But here, because the person says, "I love you," we don't interpret that in a negative way.
Well, the Commonwealth doesn't interpret "I love you" to mean really anything. What we look at is the prior behavior, and what we look at is the act of coming up from behind the victim when she had already stated 20 more times no when he asked her out, that he grabbed her from behind. She's working at her cashier. There's 3 or 4 customers in line. She's in a boxed-in area at a small enclosure, and he's coming up from behind. She doesn't know he's there. It's sexually charged conduct. She testified that she was scared after this happened, that she couldn't concentrate at work. It was certainly threatening and as well as physically offensive, and there was no legitimate purpose.
Thank you, Ms. Patton.
Thank you.
All right. Hear ye, hear ye, hear ye.